The house settled into its evening habits the way it always did after dinner. The dishwasher hummed, the dog made a circle before lying down, and the calendar on the fridge held its neat blocks of color-coded commitments. Second marriages come with systems. We had ours. We shared chores, split expenses with a spreadsheet. Neither of us pretended to be romantic, and we spoke carefully about money the way adults do when they've already learned what silence costs. That was the tone of our life together, measured, polite, functional. Nothing felt fragile. If anything, it felt sturdy because we named things plainly. The prenuptial agreement fit right into that philosophy. We talked about it over coffee, not wine, on a Saturday morning, with the paper spread between us like a home improvement plan. We both have kids, he said, tapping the table once decisively. We both worked too hard to leave things unclear. I agreed. I had my own retirement accounts, a small inheritance I hadn't touched, and a house I'd refinanced after my first divorce. He had a business, equipment loans, and an ex who still called about college expenses. The agreement wasn't a wedge, it was a fence line. Signing day was uneventful, which I remember precisely because of how unceremonious it felt. His attorney booked a conference room with beige walls and a faint smell of toner. My attorney sat beside me, flipping pages, checking initials. "This clause matches what we discussed," she said, pointing. I initiated, he initiated. Page after page, our handwriting repeated in the margins like a rhythm. The notary asked for our IDs, stamped the acknowledgement, and slid the pages back across the table. I remember the sound of the stamp. Firm. Final. We shook hands all around. No champagne, just paper. Afterward, he told me he'd take care of filing it with the county. "They'll record it," he said, rolling the document back into its envelope. "It's routine. I'll drop it off on Monday." I nodded. It made sense. He was already handling the marriage license, the insurance updates, and the beneficiary forms. Delegation is a kind of trust. I kept a scanned copy in my email, labeled with the date, and filed the memory under "We moved on" to choosing paint colors and arguing about whether the guest room needed a desk. Months passed. Life does what it does when there's no crisis to interrupt it. We attended school events for our kids, took turns cooking, and learned each other's shortcuts through town. When money came up, it was predictable. "Utilities went up this month," I'd say. "I'll cover it," he'd answer, or vice versa. There was no tension, no secrecy. If anything, the prenup made conversations easier because it had drawn the borders early. We weren't negotiating everything from scratch. We were operating inside an agreed framework. The remark that changed everything arrived disguised as small talk. We were clearing plates one night when he said, casually, "The bank likes the updated language in the agreement, makes underwriting simpler." He said it the way someone mentions a weather forecast, eyes already on the sink. I froze long enough to notice it. "Updated language?" I asked, keeping my voice level. He shrugged. "Yeah, standard stuff. They always want clarity." He turned on the faucet, the water loud enough to fill the pause. I didn't argue. I didn't accuse. I asked one more question. "When did that happen?" He rinsed a plate, stacked it carefully. "After the wedding, when we filed it." His answer was smooth, almost rehearsed, and that was the problem. Filing doesn't require updates. Recording is mechanical. I knew that because my attorney had explained it, but I let it go. I dried my hands and said, "Okay," because sometimes the smartest move is to let the conversation end exactly where the other person wants it to. Later that night, in bed, I replayed the exchange without dramatizing it. People misspeak, banks request things, language gets tweaked. None of that automatically means wrongdoing. Still, I opened my email and pulled up the scanned copy of the agreement. The file name was unchanged. The pages looked the same as they had the day we signed them, initials where they should be, clauses we'd discussed, including the one about the house and the one about spousal support that had taken the longest to negotiate. I closed my laptop without drawing any conclusions. Memory is unreliable. Documents are not. Over the next few days, I watched without making a show of it. I listened for references to lenders, attorneys, anything that might explain updated language. He talked about work, about a client dinner, about vacation dates, nothing else. At breakfast, I asked, "Which bank was that?" He answered with a name and went back to his phone. The topic didn't resurface. The absence of follow-up was its own data point. If something significant had been amended, it would have come with a conversation. At least it should have. I called my attorney under the pretense of refinancing my house. "I might need a copy of the prenup," I said. "Do you keep executed versions?" She paused. "We keep what we signed," she said. "Why?" I told her I was just organizing files. "I'll send it over," she replied. The email arrived an hour later. The attachment matched my scan, down to the smudge on the bottom corner of page 3 where the copier had hiccuped. I compared it anyway, slowly, not because I expected a difference, but because careful comparison calms me. That night, over dinner, I tried again, gently. "When you mentioned updated language," I said, "I realized I never saw anything new." He smiled, too quickly. "It was nothing you needed to see," he said. "Administrative." I nodded, speared a piece of chicken, and changed the subject to the kids' schedules. The conversation moved on because he wanted it to. I let it. Power isn't always about confrontation. Sometimes it's about timing. I didn't sleep much after that, not because I was angry, but because my brain had shifted into verification mode. The rules were simple. Don't alert him. Don't speculate. Check the record. If nothing had changed, the clerk's file would confirm it and I could put the thought away. If something had changed, I needed to know exactly what and when. Marriage doesn't erase the need for independent confirmation. It sharpens it. I decided that before I let another day pass, I would stop relying on reassurances and look at what was actually on file. The next morning, I packed my bag for work and added one extra item, my ID. On my lunch break, I would walk into the county clerk's office and request the recorded document by name and date. It was a simple administrative step, the kind people take every day without fanfare. I didn't frame it as an investigation. I framed it as housekeeping. As I locked the door behind me, I felt steady, not suspicious. I was just going to see what the record said. The county clerk's office sat between the tax assessor and the records warehouse, a low building with tinted windows and a flag that snapped in the winter wind. Inside, the air smelled faintly of paper and disinfectant. A digital sign ticked numbers forward with a soft chime. I took a ticket and sat on a molded plastic chair watching people approach the counter with deeds, birth certificates, divorce decrees. Nobody looked nervous. That steadied me. This wasn't a confrontation or a gamble. It was a request for a public record, the kind the system was built to handle without emotion. When my number appeared, I stepped up and slid my ID across the counter. "I'm looking for a recorded prenuptial agreement," I said. "Names are mine and my husband's. Date should be about 6 weeks ago." The clerk, a woman in her 50s with reading glasses on a chain, typed without looking at me. "Recorded instruments are indexed by name and date," she said, reciting the process as comfort. "Do you know the recording date?" I shook my head. "It was supposed to be filed shortly after the wedding." She nodded. "We'll search the window." Her screen reflected in the glass between us, lines of text scrolling past as she refined the search. "Here we go," she said finally. "One hit." She turned the monitor slightly so I could see the header, our names, the instrument type, a recording stamp dated 3 weeks after the wedding. "You'll want a copy?" I said yes. She printed it without comment, stapled the pages, and stamped them certified. The motion was practiced, efficiently. If this was unusual, she didn't signal it. I took the packet to a small counter near the wall and began to read. The first page looked right. Caption, parties, effective date. I flipped to the signature page. There was my signature, the one I recognized by the slight slant on the last letter. His signature matched, bold and consistent. The notary block was there, complete with commission number and expiration date. For a moment, relief washed through me. Maybe I had misheard him. Maybe updated language was banker shorthand for something else entirely. Then I turned back to page 2 and slowed down. The font size was smaller than I remembered. The margins were tighter. The clause numbers skipped differently. I found the section on separate property and read it carefully, line by line. The house was still listed, but the language around appreciation had changed. It wasn't dramatic, but it was precise in a way the original had not been. I flipped to the spousal support section and felt the shift in my chest before my mind caught up. The duration cap was shorter. The conditions are narrower. This wasn't an interpretation, it was a substitution. I went back to the clerk, keeping my voice even. "Is this the only version on record?" I asked. She glanced at the packet, then at her screen. "This is the only instrument recorded under your names," she said. "If there was another, it wasn't submitted here." I asked, "Is there a way to see if an earlier version was rejected or replaced?" She shook her head. "We don't replace instruments. We record what's presented. If there was an earlier agreement, it would have its own recording number." She paused, then added, "You can search by date range if you want." We searched. Wedding week. The week after. Nothing. The printer stayed quiet. "So this," I said, tapping the packet, "is what the county has?" She nodded. "Yes, ma'am." I thanked her and stepped aside, my mind already reorganizing. The question wasn't whether the recorded agreement differed from the one I signed. It did. The question was how that difference existed with my signature intact. That required a sequence: notarization, execution, recording. Somewhere in that chain, pages had moved. I sat down again and compared sections I knew by heart. The inheritance carve-out was more expansive. The business valuation method had been adjusted to favor him. Each change was defensible on its own, the kind of revision a lawyer might suggest. Together, they formed a pattern. The agreement on file reflected his interests with surgical efficiency. It wasn't sloppy. It was careful. I imagined the original pages laid out on a desk, signature pages lifted, new text slid underneath, staples reapplied. The thought didn't spike my pulse, it narrowed my focus. Before leaving, I asked the clerk one more question. "Can you print the recording metadata?" She looked at me for a second, then nodded. "It'll show the submission date and method." She handed me another page with timestamps and a note indicating in-person submission. I folded it into the packet. Outside, the cold air felt sharper. I stood by my car and let myself acknowledge the facts without layering them with feeling. A different agreement was on file. It carried my signature. It had been recorded weeks after the wedding. There was no record of the original. At home that evening, I placed the certified copy next to my scanned version on the dining table and went clause by clause, marking differences with sticky notes. I didn't call him into the room. I didn't ask for explanations. I cooked dinner, asked about his day, and listened as he talked about a delayed shipment. When he mentioned a call with his banker, I noted it and asked nothing. The evidence didn't need commentary. It needed context and confirmation. Later, I emailed my attorney again, this time attaching photos of the recorded document. "Is this what you have?" I asked. She replied quickly. "No," she wrote, "this is not the version we executed." She asked me to bring both copies to her office. I scheduled the appointment for the next morning. As I closed my laptop, I understood something that had been abstract before. Public records don't argue. They sit where anyone can see them, waiting for the right question. That night, I lay awake and considered whether there could be an innocent explanation left. A clerical error? Unlikely, given the precision of the changes. A mutual amendment I'd forgotten? Impossible. My attorney would have been involved. The simplest explanation was also the most uncomfortable. Someone had presented a different document for recording, one that relied on the authenticity of our signatures to pass scrutiny. That someone had access to the originals after notarization. There were only 2 people. By morning, the conclusion settled into place without drama.
The agreement I signed existed in my files and my attorney's. The agreement on record existed at the county. They were not the same. There was no third copy bridging the gap. Whatever happened occurred after the notary stamp dried and before the clerk logged the instrument. As I gathered the packets to leave for my attorney's office, the final piece clicked into focus. If there had ever been an earlier recording, it was gone. The original wasn't just altered, it was missing. My attorney's office hadn't changed since the last time I sat there to sign the agreement I thought was final. Same framed certificates, same low hum from the copier down the hall. She didn't offer coffee. She didn't need to. I laid the two versions on her desk without commentary. She adjusted her glasses, read in silence, then looked up. "These aren't the same," she said, not as a question. I nodded. "The one on file," she continued, tapping the certified copy, "was not prepared by my office. That statement alone narrowed the universe of explanations to something manageable and grim." She pulled our executed copy from her file cabinet and placed it next to the recorded version. "Let's slow this down," she said. We compared page numbers, paragraph breaks, spacing. "Signature pages match," she observed. "Interior pages don't." I asked, "Is it possible the county made an error?" She shook her head. "They record what's submitted. They don't edit documents." Her tone was neutral, but the implication was clear. If this was recorded, someone submitted it as a complete instrument, someone who had reason to believe it would withstand casual scrutiny. We talked about the sequence. "Walk me through signing day," she said. I described the conference room, the notary stamp, the staples. "Did anyone leave with a full copy?" "Yes." "Did anyone take the original after execution?" "My husband had. He said he'd file it." She made a note. "And there were no amendments discussed or drafted after that?" "None." She leaned back. "Then the only way this happens," she said carefully, "is page substitution after notarization." She didn't say fraud yet. She didn't have to. She suggested a forensic document examiner. "Not for the signatures," she clarified, "for the pages." I agreed. By the afternoon, we were in a small office with a man who spoke in measurements and probabilities. He scanned both agreements, zoomed into margins, and pointed out differences in printer signatures and toner density. These interior pages were printed on a different machine and on a different date. He showed us metadata embedded in the files my attorney had retained. The recorded version's interior pages post-dated the notarization by several days. The signature pages did not. "So the signatures are genuine," he said. He nodded. "They appear to be, but they were affixed to a different body of text." He paused. "In plain terms, the agreement was altered after it was notarized." My attorney asked, "Can you document that?" He smiled thinly. "That's what I do." He outlined his report, his conclusions framed in language courts accept. I listened without interrupting. This wasn't about outrage. It was about building something that couldn't be waved away.
Back at my attorney's office, we turned to emails. "Did he communicate with anyone about revisions?" she asked. I didn't have access to his work email, but I had shared accounts for household matters. We searched for keywords. Nothing. Then she asked, "What about the paralegal at his lawyer's office?" I hadn't thought of that. We subpoenaed records quietly, framed as a routine request tied to the refinance I'd mentioned earlier. The response came 2 days later, an email thread discussing revised inserts and final compilation dated after the wedding. The emails were clinical, almost boring. "Please swap pages 3 to 8 per attached," one read. "Signature pages already executed." There was no dramatic language, no confession, just logistics. The sender was my husband. The recipient was a paralegal who responded with file confirmations in print times. My attorney printed the thread and placed it in a folder labeled simply "Evidence." "This shows intent," she said, "and knowledge." I asked, "What about the notary?" She shook her head. "The notary acknowledged the signatures. That part is legitimate. The problem is what happened after."
At home, I acted no differently. We talked about groceries and weekend plans. He mentioned a mediation clause in the agreement one night, almost offhand. At least we agreed to mediate if things ever got rough, he said. I nodded. That's smart, I replied. Inside, I noted the irony. Mediation was no longer a hypothetical, it was a stage, and stages have lighting. Timing mattered. If I confronted him now, he'd have time to shape a narrative, claim misunderstanding, muddy the sequence. I wasn't interested in debates. I was interested in outcomes. My attorney laid out options. We can confront him directly, she said, or we can let this surface in a formal setting. I chose the latter. Mediation, I said. Let him rely on the recorded version. She understood immediately. We'll say nothing until then, she said. We'll prepare. Preparation meant assembling the forensic report, the email thread, the certified copies and affidavits from my attorney and the examiner. It meant rehearsing explanations that were precise, unemotional, and grounded in process. The weeks leading up to mediation were an exercise in restraint. At dinner, he talked about asset division hypotheticals, speaking as if the recorded agreement was unassailable. It's all spelled out, he said once, smiling. I listened. I asked clarifying questions that encouraged him to articulate his reliance on the altered terms. My attorney advised me to note dates and phrases. Let him commit to the document, she said, in his own words. I did, quietly, without visible reaction. On the day we scheduled mediation, I signed the paperwork with a steady hand. The mediator's office sent a checklist, financial disclosures, copies of agreements, position statements. My husband volunteered to send the prenup. I let him. When his email arrived attaching the recorded version, I forwarded it to my attorney without comment. She replied, "Good." That was all. The file grew thicker, the narrative sharpened. Nothing about my daily life changed, and that was the point. Stability is disarming. The night before mediation, I reviewed the packet one last time. The forensic report led with conclusions, not speculation. The emails were organized chronologically. The certified copies bore stamps and seals. There was no excess, no adjectives, just facts arranged to tell a story the law recognizes. I slept well, not because I felt vindicated, but because uncertainty had been replaced by sequence. I knew what had happened. I knew how it would surface. In the morning, I put on a neutral suit, gathered my folder, and drove to the mediator's office without rehearsing a speech. I didn't need one. The record would speak for itself when the room was ready. The mediator's office was designed to make people lower their voices. Soft gray walls, a round table, a tray with coffee that had already cooled by the time we arrived. My husband sat across from me, relaxed, in the way people are when they believe the paperwork favors them. He greeted the mediator by first name, made a brief joke about traffic, and placed his binder on the table with practiced confidence. I set mine down quietly. No props, no expressions, just alignment with the plan. The mediator outlined the process in a measured tone: confidentiality, voluntary participation, a goal of resolution. My husband nodded along, hands folded. When asked to summarize his position, he didn't hesitate. He said, "We have a prenuptial agreement on record," he sliding a copy toward the center. "It governs asset division and support. I'm prepared to follow it as written." He spoke clearly, as if reading from something internalized. I noticed the word "on record." I filed it away. The mediator turned to me. "Your understanding?" he asked. I met his eyes and said, "I agree that there is a prenuptial agreement on record." I let the sentence end there. Silence did its work. The mediator asked my husband to walk through the key terms. He did, clause by clause, explaining the shortened support duration, the valuation method, the appreciation language. He spoke as though teaching a class. Each explanation tightened the net. He was authenticating the altered agreement in his own voice. When he finished, the mediator looked at me again. "Any response?" I opened my binder and placed two documents side by side in front of him, aligned so the headers matched. Yes, I said. I'd like to clarify which agreement governs. I slid the certified copy forward and then the executed copy from my attorney's file. These are not the same document. The mediator leaned in. My husband frowned just slightly. They are, he said quickly. One is the recorded version. I nodded. That's correct, I said, and the other is the version we executed. The mediator paused the session. He said, I need to understand this. Counsel may need to be involved. My husband's attorney, who had joined by phone, spoke up. The recorded instrument controls. I didn't respond. I handed over the forensic report. This addresses the discrepancy, I said. The mediator skimmed the executive summary, then stopped reading. We should suspend mediation, he said. This raises issues beyond negotiation. My husband's confidence evaporated in increments. This is a misunderstanding, administrative. The mediator shook his head. The report indicates page substitution after notarization. That's not administrative. He looked at me. Is there additional documentation? I passed him the email thread. He read silently, then looked up. We're done here for today, he said. This will need court review. The room changed temperature. My husband leaned back, crossing his arms. This is being blown out of proportion, he said. I didn't answer. The mediator instructed both parties to contact counsel. As we stood to leave, my husband said, low enough to avoid the mediator's ear, "You could have talked to me." I met his gaze. "I am," I said. It was the only direct sentence I had spoken to him all morning. Within a week, the matter was before a judge. The courtroom was smaller than I expected, the kind that handles motions and sanctions without ceremony. Both agreements were marked as exhibits. The forensic examiner testified succinctly. The emails were entered without objection. My husband's attorney attempted to argue intent, suggesting a good faith effort to clarify terms. The judge interrupted. After notarization, she asked, with executed signature pages? The question hung there, unanswered. When my husband took the stand, his earlier confidence had thinned into something brittle. He claimed he believed amendments were permitted. The judge asked who advised him of that. He named no one. She asked why my attorney wasn't involved. He offered no explanation. She asked about the emails. He acknowledged sending them. Each answer narrowed the path. The law doesn't need outrage to function. It needs sequence and proof. The ruling came quickly. The court enforces the original executed agreement, the judge said. The recorded instrument is void as altered. She imposed sanctions for abuse of process and referred the matter for potential disciplinary review regarding the paralegal's involvement. She ordered the county record corrected. The gavel tapped once. It was finished. Not dramatic, definitive. Outside the courtroom, there was no argument. My husband avoided my eyes. His attorney spoke in low tones about next steps. Mine gathered the files. "We're done," she said. I nodded. As I walked to my car, the weight of it settled. Not triumph, not relief, but closure shaped by procedure. The room where it changed wasn't the courtroom or the mediator's office. It was the moment the record replaced reassurance, and from there, everything followed. The order arrived by mail 3 days later, folded once, stamped with a date that made it official in a way conversation never could. The court enforced the original prenuptial agreement in full. The language was plain, almost spare. It didn't describe betrayal or motive. It didn't speculate about character. It listed findings, cited evidence, and applied consequences. The altered agreement was declared void ab initio. Sanctions were assessed for abuse of process. The county clerk was directed to correct the public record. The system did what it is designed to do when presented with facts arranged in sequence. The financial outcomes were not theatrical. The house remained separate property as originally agreed. Appreciation was treated the way we had negotiated it on that beige conference table months earlier. Spousal support followed the original duration and terms, neither generous nor punitive, just exact. The business valuation reverted to the method we had debated line by line. There were no surprise windfalls, no symbolic penalties beyond the sanctions themselves. The law restored balance without adding commentary, which is its quiet strength. The sanctions mattered more than the numbers. They weren't crushing, but they were specific. Fees awarded, costs reimbursed, a written finding that the alteration constituted misconduct. The judge's referral regarding the paralegal sent a signal beyond our case. I didn't follow up on that thread. It wasn't my role. My role had been to bring the discrepancy forward intact. What happened after belonged to the institutions tasked with oversight. Closure doesn't require witnessing every consequence. My husband's professional circle absorbed the news in the way communities do when something uncomfortable surfaces, not with headlines, but with pauses, a partnership opportunity that stalled, a client who asked for clarification, a lawyer who stopped returning calls as quickly. Reputation isn't lost in a single moment, it thins. He didn't contest the ruling, he didn't appeal. The silence after the order was its own acknowledgement. The document he'd relied on could no longer protect him. We finalized the divorce efficiently. No additional hearings, no renegotiation. The enforced agreement provided the framework, and within it we closed accounts, transferred titles, and updated beneficiaries. We communicated through counsel and a shared checklist. When we did speak directly, it was brief and logistical. The marriage had already ended long before the court said so. What remained was administration. There is dignity in finishing things cleanly, even when the path there is sharp. On the day the corrected record was filed, my attorney emailed me a scanned confirmation from the county. The original agreement, properly recorded, replaced the altered version in the index. Anyone searching our names would see the truth without knowing the story behind it. That mattered to me more than I expected. Public records are communal memories. They outlast explanations. Having the correct document there felt like restoring something that didn't belong to me alone, but to the integrity of the process. Friends asked careful questions. Are you okay? Was it complicated? I answered honestly without detail. It's resolved, I said. The court enforced what we signed. I didn't share the mechanics unless asked directly, and even then I kept it factual. There was no need to recruit sympathy or outrage. The story stood on its own without amplification. In a world that rewards spectacle, restraint felt like control. Alone in the house one evening, I opened the folder where I keep documents that matter: birth certificates, deeds, insurance policies. I placed the enforced agreement there behind a tab labeled Marriage. It felt appropriate, not sentimental, accurate. The agreement had done what it was meant to do, define boundaries when feelings were insufficient. It hadn't prevented harm, but it had provided a standard the court could return to when trust failed. That's not cynicism, that's design. I thought about the signing day again, the notary stamp, the quiet confidence we both had as we initiated margins. I didn't regret trusting him. Regret implies error in judgment. I had exercised judgment by insisting on a prenup in the first place, by retaining independent counsel, by keeping copies. Where I had delegated filing, I had later verified. The system worked because I had respected it enough to use it fully. Love didn't excuse the process. The process didn't negate love. They simply occupied different lanes. The question people asked most, when they finally asked it plainly, was whether I would do anything differently. I considered it each time before answering. I would still insist on independent counsel, and I would still verify the filings myself. That answer disappointed some. They wanted a lesson about intuition or betrayal. The lesson was narrower and more practical. Trust is not a substitute for confirmation, especially not when the stakes include children, assets, and the shape of your future. In quieter moments, I let myself consider the alternative path. What if I had confronted him at the sink that night? What if I had accepted a verbal explanation and never gone to the clerk? The altered agreement would have governed everything, silently reshaping outcomes under the cover of my own signature. The law would have enforced it because the record would have supported it. The difference between that outcome and this one was not drama or courage. It was a lunch-hour visit to a public office and a refusal to accept reassurance as proof. The case closed without ceremony, no further motions, no lingering threads. The court moved on, as it always does. I moved on too, but with a recalibrated understanding of what respect looks like in adult partnerships. It looks like transparency that survives scrutiny. It looks like counsel that answers to you alone. It looks like documents that say exactly what you agreed to say, filed exactly where they should be. Anything less is a gamble disguised as romance. When I tell the story now, I stop where the order was enforced. I don't speculate about his motives beyond what the record shows. I don't frame myself as naive or heroic. I was attentive. I was methodical. The outcome flowed from that. The audience can decide what it means for them, whether love should ever bypass independent counsel, whether trust without verification is intimacy or exposure. The court answered its part. The rest is a question each marriage has to confront on its own. If this story made you pause, ask yourself where you've relied on reassurance instead of records. Share this with someone navigating a second marriage, a blended family, or a major financial decision. And if you want more real-world stories about quiet decisions that change everything, subscribe and stay with me. The next one might hit closer than you expect.